Good morning. Are you Caitlin Talmore? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Talmore, in cause number 25, DCCR 0595, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from April 4th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State Senators number 1.
No objection.
It's admitted. Is there any evidence that Ms. Talmore is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
My little Aggie.
I know. Good morning. Are you Hillary Lawrence? And Ms. Lawrence was previously in court on cause number 25, DCCR 0296, entered a plea of guilty to the state jail felony offense of theft of service. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, I have.
Are there any additions or
Not
corrections?
more, Judge.
Not from the state judge.
And so the car is still missing, so restitution would be the $25,000?
As best I can tell, Judge, honestly, the Avis doesn't do a very good job of tracking these things.
Well, it's hard to
I know.
feel comfortable ordering that much restitution if the car. Ms. Lawrence, you don't have any idea, do you, if the car ever got returned or what happened to the car?
I'm ready to a family member, and I don't. That person's in jail, so I don't know what happened.
Oh, okay.
Judge, I'll just note for the record, probation attempted multiple times to get
That's
a
what I'm
confirmation of the
seeing.
whereabouts from Avis, and they weren't helpful.
Okay, then I'm not going to order it.
Fine
Okay.
with me, Your Honor.
Okay, thank you, Mr. Nichols. All right, I'm going to, any reason not to go forward?
No, Your Honor.
Ms. Lawrence, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. Because there's not restitution, I am going to order a fine of $500 and order that you follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you complete the probation, at the end, the case is actually dismissed. You'll never have a felony conviction. In fact, if you do everything correctly and get things done up front, community service and things like that, I sign early terminations for probation all the time. You may not even have to do that 5 years, but that's going to be up to you to get it done properly and the way it's supposed to. If you don't do that and you violate the condition of probation in any way, you can be brought back into court, found guilty of the offense, which means you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification. This shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. All right, good luck to you, ma'am. Steph. Good morning. Are you Stephen Boudwin?
Yes.
And Mr. Boudwin was previously in court, entered a plea of guilty to the third-degree felony offense of lesser lesser included offense of attempted robbery. I've received the pre-sentence report. Has everyone had an opportunity to review the report? Are there additions or corrections?
Judge, I just would like to state for the record, for the court's recollection, that in this case, the complainant via her mother called the court several times, called me several times, came up to the office several times, expressing her fear of the defendant, to which the court agreed to increase his bond, to which she then bonded him out. So that's all I wanted to add on that.
Okay. All right, then I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent, understood that plea. Going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $250 fine and to follow all of the rules and conditions of probation. It is a condition of your probation that you have no contact or communication with Janiyah Lewis. We've gone through this. She cannot give you permission at this point to violate that condition that I've placed on your probation. So whatever the relationship is, at this point, it's over. If there's some options later, you talk to your probation officer and you guys are trying to work things out, there's certain ways you can do that appropriately and through probation. And then I would consider lifting that no contact, but not until then. So she can't say it's okay, come over, because then if something happens, y'all get in an argument, she calls, you're going to prison, not her. You understand? All right, so if you do everything you're supposed to on this probation, it's an excellent opportunity because you don't have the felony conviction on your record. At the end of the probation period, if you successfully complete it, the case is actually dismissed. You'll never have the felony conviction. The other side of that is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could be sentenced anywhere in the range of punishment, which is up to 10 years. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good luck to you, sir. This is Mr. Hoffpowers. Castaneda. Good morning, sir. You're Timoteo Castaneda?
Yes, Mom.
And Mr. Castaneda, in cause number 25 DCCR 0360, is charged with indecency with a child by sexual contact. Mr. Crenshaw.
Judge, we're still, I'm working with Mr. Hoffpower to reach a plea resolution. We just haven't been able to do it yet. But if we could come back, please, I believe we'll have a resolution on the next set.
Okay, sounds good. Any issues that you see notated?
No, Your Honor, just plenty notes about discussions with Mr. Crenshaw.
Mr. Castaneda, if you'll just stay in touch with Mr. Crenshaw so that you guys can visit before that next court date, and then we'll see you back then, okay? You're free to go. And I'll hold the other two while you do that paperwork. Good morning. You're near Benur?
Yes, ma'am.
And Mr. Benur's case is set for trial. This is 22-40828, Monday.
If you love seeing
Like watching courtroom pressure explode in real time? Make sure you subscribe and tap that bell. Every week, we take you inside real cases where every decision could change someone's life forever.
December, and what is the announcement?
Judge, we're ready.
State ready.
With regard to the issues that we began discussion of, and I gave some time for Mr. Gertz to be able to reach out with investigation on other complaining witnesses, has all that been taken care of?
From our standpoint, Judge, we've had no ability to get anyone to speak with us.
Okay.
So that's their choice,
Sure.
obviously, but we've made the effort to have that done.
So what I need to do then is prior to that Monday, make a ruling. We probably need just a little bit of time for them to.
I think one of the challenges I have, Judge, is I'd like to, what we had, just my recollection is what we had last time was essentially a proffer by an investigator, just proffering what other people said.
Right.
But I don't feel like we have the details, sort of police report level details from any of these allegations, if you will, so I guess I just feels like that would be discoverable, whatever the state has in their possession about these interviews.
Have there been any?
There are no written statements, Judge. We made, in fact, I don't know that we were even under an obligation to give as much detail as we gave. We gave him notice of these witnesses that they exist and the nature of what their testimony might be. But The short answer, Your Honor, is been no written statement.
And have they talked with just investigators, or have they talked with detectives from other agencies, or just within your office?
Just within our office,
Okay.
to the extent that I'm aware of, Judge.
Okay, so there aren't any police reports or anything like
Not
that?
that I'm aware of.
I think what I'm going to need to do, and I know I made some pretty detailed notes when we were here before, is make obviously the ruling on which, if any or all, I'm going to allow. And so, there's my notes, look at that. I don't know that I need, if there is no other, so there were 4, correct? We used initials. We had an initial of SM, which was a 2000 case, tummy tuck. There was some pretty detailed information that was given on that one. There was MN, which was a 1992 sinus issue with some other issues that came to light that time. And then we had a TK that I think had become now a TR from 2022. Also some details about that one. And then an RD from 2015 was a tummy tuck. Oh, and then one more, but that one hadn't been contacted back. In RL, is there any
That's correct.
notation that one is, so,
We
okay,
have not had any subsequent contact with RA.
all right. So, if there is no other, if there aren't any other police reports, and the, do you want time early one day this week to actually have an argument hearing? Do y'all just want me to make my decision based on what I have?
I think it'd probably be better to do it written by submission and let the court rule on it next week sometime.
Okay.
I don't have anything additional to add. I'm okay with the court just making a ruling.
Is that your firm?
The answer is yes. I'm okay with the court just making a ruling without any additional argument. Just make sure it's all completely off.
Okay, so what I'd like is if you guys will get that, anything written. I think, Mr.
I think I gave
You
a
already,
copy.
you already did, I'm pretty sure. And so what I'll do, if you want to have anything to add to yours, you're welcome to do that. And then if you just want to do a response in writing, I would really like that, if possible, by Thursday. Are you in trial this week? By Thursday of this week.
I'm not in trial now this week.
I'd like to make that ruling before the end of this week so that you all know while we're off next week what to be preparing for. I anticipate this will be the #1 trial, obviously. I think we've talked about that and making it a special setting because of the age and the fact that we've already gone through it. So I want to make that ruling by Friday. So I'll be around. Obviously, I'm in trial, and I'll make that and give it to you guys by email or by an order. Okay?
Yes, Judge.
Judge, the court has already ruled previously in a previous hearing subsequent to the trial that the court would allow this case to be off of YouTube. We just reminded the court of that decision that I believe was made a while back, and asked the court to do that once we begin trial on the 1st.
Did I?
I don't recall that, Judge.
Why would I have done that?
I believe.
I mean, you may have asked for it, but I don't remember saying that I would. I think if the complaining witnesses have an issue, then I would be, if I recall, I don't remember, I thought it was this case where I talked about potentially during certain testimony, blurring it out or blacking out certain things, but I don't, if you want to do something, a brief in writing, a short, something about what your request is and why, I don't recall actually or saying that I for sure would not do that. That doesn't, I remember maybe having the discussion, but I don't remember saying for sure I would.
And just doesn't the facts for this case are distinguishable from the typical case where.
Sure. I mean, I never put child
Yeah,
cases
okay.
on, and typically I primarily leave it up to a complaining witness or something like that, who's disclosing, private certain information. But I will take what you have to say into consideration. If you will also reach out to, I think the complaining witness, I mean, we had it on last time. If she's still okay with that, at least just shoot me an email and let me know, and then put whatever you need in writing, and then I'll make that decision when it gets a little closer.
Okay.
Anything else that you guys know of that we will need to address pre-trial on this one?
Not from the state judge.
Okay, all right, then I'll make that ruling again on those additional witnesses by Friday.
Okay.
All right, stay in touch with Mr. Gertz. He'll let you know when you need to be back. And then, Mr. Gertz, you have a Jonathan Zcaff.
This session inside Judge Raquel West's courtroom was packed with tension and high-stakes decisions, each case proving just how fast your future can change with one wrong move. First up, Stephen Bud Wynn. He's already on thin ice with a third-degree felony probation charge. Judge West didn't hold back. One slip-up, especially contacting someone he's legally forbidden from seeing, and it's straight to prison. His case shows just how quickly freedom can disappear when rules are ignored. Next, Hillary Lawrence. She was convicted of a state jail felony for theft of service. Judge West offered a lifeline: follow probation perfectly, and that felony might never stain her record. It's the ultimate balance, punishment, but also a real chance to rebuild. Then, Caitlin Talmore, who pleaded guilty to evading arrest with a vehicle. Before sentencing, Judge West ordered competency reviews and procedures. Probation, jail time. Everyone in the room was left holding their breath. And finally, Tamonte Castaneda. The charge: indecency with a child by sexual contact. His case is still deep in negotiations and pre-trial preparation, a clear reminder of how carefully the court handles the most serious allegations. Across these cases, one thing is crystal clear: Judge Raquel West doesn't play games. She demands accountability while still allowing defendants a path to stay out of prison, if they follow every rule. If you found today's breakdown as gripping as the courtroom itself, make sure you hit like, subscribe, and turn on those notifications. More real-life courtroom showdowns are on the way, and you won't want to miss a single second.